And hello there, and welcome to the Employment Law Show. John Scholes here, and Lior Samfiru. He is not with me. We are practicing our physical distancing to the max. He's somewhere on planet Earth. We're not sure where, but either way, he's with me in spirit and on the other side. So good to see you, pal. Kind of. We're going to continue on doing what we always do every week here with the Employment Law Show. Anytime you want to reach out, that remains the same. 1-855-821-5900. help@employmentlawyer.ca. We got a lot of stuff to cover on the show today, Lior. Employment rights during COVID-19 pandemic. That's going to be the basic gloss over the entire show. But for the week that was, I know you wanted to talk about this topic because it is a hot one. We've done this for the last, I would say, 2 weeks across the country on our radio shows, and all the phone calls we've gotten so far have all been concerning COVID-19 and how it affects the workplace, whether you're an employee or an employer. So it's pretty important stuff, pal. So the week that was, I know you wanted to carry on in that regard, right?
Hey, John, thank you. And I am happy to be here because there's still so many questions that need to be answered all day, every day. I mean, I haven't been eating. I've barely been sleeping because I've been fielding questions from people calling or emailing me, wanting to know what their rights are. I've said this for years, and people that watch our show know this, that employment rights are so important, but they're that much more important right now. You may have lost your job. Many people, probably hundreds of thousands, maybe into the millions by the time this is all over, are going to lose their job, at least temporarily. So we need to understand, and people need to understand what their rights are, what their options are, how are they going to get paid, how are they going to support their family. So we're here to talk to you about that. And of course, if you want to talk to me about your specific situation, if you're concerned, you don't know if you have rights, let me know. Contact me. We'll give you my contact info throughout the show, phone and email. Remember, I wanted the theme of this show to be this, that employment laws don't get suspended. They're not suspended just because of the virus, okay? Employment laws still apply, and they apply for the most part in the same way. So you still have rights. Employers still have obligations, and we want to talk about those. Now, in terms of the week that was, by the way, we're going to cover a lot of topics related to COVID-19 and employment law on this show, but I'll start off with a quick story because I have more and more people calling me with this situation. I spoke with a lady who worked for an accounting firm, just really her and the owner and one other employee. And the owner of the accounting firm, the accountant, was recently away. He came back, and he was asked, of course, to self-quarantine or self-isolate for 14 days. Well, he decided that it's not for him, that he's fine, he should come into work. So he came into work, and the problem was the coworker, the person that called me, is now very concerned. It's like, I don't want to be working shoulder to shoulder close to him because I'm afraid I'm going to get the virus. He was away. So what do I do? So here's the thing, John. There's an overarching principle, and this is important to remember, that an employer has to protect your health. That's a fundamental obligation that applies in all situations, and it applies especially right now. Your employer has to protect your health. Take all reasonable measures to do that. And if an employer unnecessarily puts you at risk like this employer did, there are two options. The first option is you can engage in what we call a work refusal. A work refusal is a situation where if your work is unsafe, you can refuse to work, and the Ministry of Labor has to be called in to investigate and determine if, in fact, the work is unsafe. You cannot be punished, and you have to be paid. Number one. Number two is you can actually treat this situation, this endangerment, if you will, as a constructive dismissal. Your employer has to keep you safe, and if they don't, you may be able to say, that's it. It's as if you've let me go because you haven't met your fundamental obligation to me, and you can leave and pursue severance. So if you are put in undue, in a situation with undue worries, or in situations where you're exposed more than you should be or could be to the virus, you may have recourse, whether it's a constructive dismissal or a work refusals. And employers, be smart. Protect your employees. It's your legal obligation. It's the right thing to do.
And reaching out, by the way, you can still do that anytime. That hasn't changed. 1-855-821-5900. help@employmentlawyer.ca. And a website you can spend some time on now that we all have a little more time at home, right? pocketemploymentlawyer.ca. That is a very robust website. Has been around probably for almost half a year now, and it is full of employment law information and stuff you should know anyway. Employmentlawyer.ca, that's where you want to go if you want to catch a past radio show. We broadcast across the country on all kinds of formats and stations. We get a ton of calls. Now, a lot of them have been COVID-19 skewed of late, but we like to play them back here, Lior, and talk about them. So we'll get to our first call for today right now.
Right.
My partner, she received an email that said that she's been laid off. She is a dental hygienist for 20 years at the same practice. We're just wondering what her recourse is.
When laid off, was her employer telling her that's it, you're gone, or it's a temporary thing and we hope to reopen and call you back at some point down the road?
It wasn't clear. The message was that you're laid off and perhaps it'll be revisited later on, but there hasn't been any definitive answer.
Okay, yeah. This right to the theme we're talking about, right? Exactly.
It is exactly. And when I started off the show by talking about the fact that employment laws are not suspended during this pandemic, when it comes to temporary layoff, that is a key thing to remember. So our regular viewers know this, and I've said this on the show many times, that a temporary layoff in most situations is illegal. And what I mean by that is, if your employer lays you off temporarily, you have a right to treat that as a termination. So you don't have to accept it. Your company cannot impose that on you. And if you treat that as a termination, the company has to pay you severance. Now, the same thing applies here in the pandemic. Even though businesses may be struggling, the laws don't get suspended. And it's important to remember that. If the laws don't get suspended, for this person, she's a dental hygienist, her employer suspended her employment, whether it's laid off temporarily or they're feeling that they should be letting her go completely, she can treat that, if she chooses, as a termination and get severance. Now, there's a couple of reasons why I've been speaking with a lot of people that have chosen to do that. The first reason is they need the money now. They may not be able to live on EI or the new CERB benefit that the company has, that the government has implemented. They need their full compensation, and severance provides them with their full compensation for a period of time. And the other reason is they're concerned about the viability of the company long term. If the company doesn't come out of this, then they're not going to get anything. So for those reasons, you can pursue your severance. Now, for this person, after 20 years of employment, she probably could be getting anywhere from 18 to 24 months pay. And an easy and handy tool to go to figure out how much you're owed is pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We'll talk about that more later. And that's what she's owed here, John. So her option is she can accept this layoff, see what happens. That is dangerous. Or she could treat that as a termination now and get her severance.
That second point you just made is that should be a bit of an alarm bell. We hope there's not a lot of businesses that are going to lose business and go out of business. It's probably going to happen more than we can imagine. But that's one thing. You can't pursue severance if a company is bankrupt, right? It's blood from a stone. You can't get anything at that point, can you?
It's exactly the blood from a stone. And big story in the news, the last year or so was Sears. Hundreds if not thousands of employees that lost their job because they were bankrupt. They didn't get paid. So no, if a company is bankrupt, then you cannot get severance. Keep in mind, company not operating or even being out of business does not mean bankrupt. A company could be out of business and still have the obligation and the ability to pay you the severance that you're owed. But if they're bankrupt, then no, you don't get anything. So really, if that is a concern that down the road they may be in that situation, you may want to pursue your entitlements, your legal entitlements now.
Again, help at employmentlawyer.ca. That's the email address, 1-855-821-5900. Want to move on to this, pal, and that is employment rights during the COVID-19 pandemic. Number one, what are an employer's responsibilities where a safe work environment is concerned? That's also been a topic recently, right?
It is a huge topic, and we touched on that right at the top of the show just a little bit. So an employer has to keep the workplace safe. An employer has to protect their employees and not put their employees in a position where they're coming under undue risk. So what this means, at least as relates to COVID-19, is your employer has to still allow you to practice safe social distancing and physical distancing at the workplace. So they should not be putting you in a situation where, even if you're continuing to work, where you're working shoulder to shoulder in a room crowded with people. That is not acceptable right now. That is dangerous, and that is something that an employer is expected to prevent from happening. An employer should allow employees, where at all possible, to work from home, okay? Because one of the ways to practice safe social distancing is by working from home. So if your employer has that ability, they should do that. That is the safe thing to do. And of course, your employer should follow all the guidelines from the health officials in terms of requiring people to stay home if they're exhibiting symptoms, if they came back from out of the country, if they're particularly vulnerable, or if there's particularly vulnerable people in the workplace. So all these guidelines from the health authorities must be followed, and if they're not, there could be recourse, just as I said at the top of the show.
That leads to the second question. If I am sent home because I'm sick or traveled and I have to self-isolate, does my employer still have to pay me?
So if you're in a situation where you cannot work either because you have the virus or you're in isolation or you're in quarantine, then the employer actually does not have to pay you. At least they don't have to pay you your regular wages. Now, you may be able to get compensation because the employer may have sick days that you can use, a sick day policy, 2,
Right.
5, 10, whatever, sick days, and you can use those, which means while you're using those sick days, you can be paid. Your employer also may provide you with vacation days. You may have vacation days that either you can choose to use now so you can get paid, or your employer in some situations may impose that on you. The employer may decide you're using up your vacation days while you're off sick. Now, you're not going to be happy about that. I get it. But your employer is allowed to tell you when you're going to use your vacation day. So that's something to keep in mind. You can also, if you're unable to work under quarantine, you can apply for EI sickness benefits. You may also be able to apply for the new CERB benefit that the government has announced. So there are options for you to get paid, but the company doesn't have to pay you your regular wages while you're homesick.
We're talking about employment rights during the COVID-19 pandemic. If I am on a sick leave, does my employer have to hold my job while I'm off on leave?
So right now, the government has instituted new plans and new laws, really, that yes, your employer has to keep the job. So you're under what we call a protected leave of absence. By protected means your job has to be there. But really what that means is you cannot be let go just because you took that leave. It's a practical matter. If it's a situation where there is no work, and it would be the case whether you took the leave or you did not, then the company may not hold the job. A lot of employers have laid off most of their workforce, if not all their workforce. So that could still happen, but keep in mind, if that does happen, if you do lose your job because of the situation, you still have potentially, and in many cases, just as I said earlier, the ability to pursue your severance. So it's not a done deal that you don't have recourse. Far from it. Employment laws are not suspended.
If I'm not the one sick, say I have to stay home for a family member or a loved one to take care of them, is that possible?
It is possible. So family member, you can, or if you're required to stay home because your children now are not in school, they're not in daycare, so you need, of course, to care for them and provide care for them. So yes, you can be off work, and not only can you be off work without penalty, you can also apply to the new benefit, the CERB benefit, which would pay potentially up $2,000 every month. So that is a significant amount of money. So that's intended to try to encompass as many people as possible that are affected by the virus. And the government is telling us that we'll get paid within 2 weeks in those situations. So you cannot be penalized, you can be off work, and you can apply for that compensation from the government.
We're talking about your employment rights during the COVID-19 pandemic. By the way, you'll want to reach out anytime during our conversation or otherwise. 1-855-821-5900 is a good way to do so. So if business slows for my employer, can they reduce my hours, cut my pay? Can they do that stuff? Even if it's self-serving to survive, can they do it?
So again, our regular viewers know that whenever it comes to changing terms of employment, changing in hours, changing in compensation, changing in shifts, any of that, we have to start thinking about constructive dismissal every time we hear that, because the employer does not have the legal right to make unilateral changes to the terms of employment. Now, the same happens now, even though the company may have a good reason, okay? The company's not being bad or nasty. They're not picking on you. They have good financial reason. It does not suspend employment laws. So if your company changes your hours of employment, reduces them, if your company says, well, instead of working mornings, I need you to work afternoons or evenings, you have the option. It's not automatic, but you have the option to say, no, I'm not doing that. I'm not accepting that. And if your employer forces it anyway, you can treat that potentially as a constructive dismissal and leave in with your severance. And for some people, rather than taking an 80% pay cut, they may be better off to treat it as a termination, get their severance, which could in some situations be up to 2 years pay, and instead of taking a pay cut, getting paid their full entitlements, and hopefully when we come out of this, they'll be able to find a job at normal pay somewhere else.
What if my employer takes it one step further and they want to fire me because of the COVID-19 pandemic? How does that play out?
So the only exception, the only leeway that employers would have right now to do that without having to pay is a situation where the business is forced to be closed by the government. In other words,
Right.
the business is deemed to be non-essential.
Non-essential.
It's not essential, and because of that, they have no choice but to close. If the business has no choice but to close, so because that now you're out of work, then the company can't control that. There's no decision that they can make, so they won't have to pay anything, arguably, at least not for the period of time that they're forced to close. If they don't call you back as soon as they can open, yes, you may have entitlements in that situation. But in all other situations where the business can operate, is operating, if you are let go, then number one, we want to make sure you're not let go because you're sick, for example. That could be a human rights violation, or because of your ethnicity. I have heard situations of employers not treating people, from Asia, for example, properly. That's wrong. That's a human rights violation. I hate hearing that. But beyond that, severance would have to be paid. As I said earlier, pocketemploymentlawyer.ca, fastest, easiest, and completely free way to find out how much you're owed if you lost your job, COVID-19 related or otherwise.
I'll ask you one final one. Say the employer wants to dial it back a little bit. They don't fire you, but they want to put you on a temporary layoff. Can they do it? Do I have to accept it?
You do not have to accept a temporary layoff as long as the business can still operate, as long as the business is deemed an essential service. At least here in Ontario, many businesses have been deemed essential services. That's a very, very long list. So if your employer is on that list, and despite that they lay you off temporarily, you can accept the layoff and stay home and hope they call you back, or you could treat that as a termination right now and leave and get your full severance. If that's what you want to do, if you're ever in that situation and you say, no, I would rather get my full compensation right now, my full severance, give me a call. Before you do anything else, call me, email me. Let's talk about how to proceed and how to help you. It's not a complicated process, and we can certainly help.
All right, taking a medical leave on the coronavirus of the COVID-19 outbreak. We will tackle that next. In the meantime, reaching out, Lior just mentioned it, pocketemploymentlawyer.ca. You have the option on the phone, number 1-855-821-5900, and help at employmentlawyer.ca. Lots more coming up on the Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. We are working remotely. We are practicing physical and social distancing, Lior and myself, but the show must go on, as Freddie Mercury once said, so we'll get right back to it. You want to go to employmentlawyer.ca anytime. There you will find a resource to catch our long-running radio show, about 13 years, I think, now. We play the calls back from the radio show here, and we talk about them. The second phone call for today's show is coming up right now.
We cannot practice social distancing in our office. There's an office of about 20 of us that are still required to show up for work every day, and our cubicles are about a meter apart, and we all kind of work on top of one another because one function falls into another function. Paperwork is getting passed through here. So I'm just wondering what we can do to try to protect ourselves, because there's been no enhanced cleaning measures put in place in our office. They're not telling us that we can work from home, even though we do have capabilities to. I just don't know what to do in this situation.
The level of anxiety, man. We've heard this phone call so many times in the last 2 weeks. What do you think?
You can actually hear the anxiety, the stress in her voice. So there's a number of things, and I'll start off, as I said earlier, this is wrong. It's wrong from a legal standpoint. It's also wrong from just a human standpoint. If your employer can do something to protect you, as this lady suggests that their employer can, but refuses to, doesn't want to spend the money, that is a problem. Okay, that is a huge problem. So, options. There are three options as I see them. Option number one is you can engage in a work refusal. Absolutely you can. And because, number one, your employer could be doing more and is not, your employer could be allowing you to practice social and physical distancing by allowing you to work from home, and they're not.
Right.
So because of that, you can engage in a work refusal, and your employer, if people do that, your employer is not going to have a choice but to fix the problem. And also, if the employer still doesn't fix the problem, the Ministry of Labor gets called in. They investigate, and if they can determine that it's unsafe, they will order the employer to do what it's supposed to. So that is option number one, a proper and a legal work refusal. The other option, constructive dismissal. Your employer is endangering you. Your employer is putting you in a difficult situation. You may be able to say, I'm out of here. I'm going to treat that as a constructive dismissal. You drop the ball, employer, so because of that, I'm going to pursue my severance. The third option is this. I'm a lawyer, right? I'm not a doctor. But one thing you may want to consider is speak to your doctor. You clearly are stressed. I could hear the stress in the voice. If your doctor feels because of stress and anxiety you should not be working right now, your employer can give you a doctor's note. And you can be off work, and you can apply for sickness benefits. You can also apply for a short-term or long-term disability if you have that through your employer. So you can be off work legally that way. So there are a number of options, but the message here, John, for all our viewers is do not continue working in a situation where it's clearly unsafe. When there are options, don't do that. You're putting yourself and others at risk. And everything we're hearing now from the health authorities, from our government, is don't do that. Be safe. Very important.
If you have any other questions in that regard, reach out to Lior and the crew anytime, 1-855-821-5900. We'll get to the third phone call for the show today right now.
Yesterday, I received a layoff notice from my boss. It's a small dry cleaning company, and the layoff notice is 17 weeks. And I think that he shouldn't be able to exceed 13 at this time, but you can correct me. But also in the conversation of the layoff, he pointed out that he was laying off the people who are over 60 because they're more susceptible to the virus. Is that something he can do?
Come on. This guy, he can't be real.
No, it can't be. So, John, there's a number of things to unpack here. So before we even talk specifically about the layoff, let's talk about the whole age 60 issue. Man, oh man. So if I understand what she's saying that her employer is laying off people, but he's saying, I'm going to only lay off those people over 60. Well, you know what we call that, John? What do we call that?
That's a massive human rights violation. Massive.
That is a massive one with an extra cherry on top. It's not even close. You cannot treat people differently because of their age. And by the way, even if somehow deep down you have good intentions, okay, you cannot do that. You cannot decide that people that are going to work here are going to be people under 60 and the people over 60 are going to be laid off. No. Even if you think that's better for them because they're more at risk, that's not your call, and it's completely and utterly illegal to do that. So this employer is going to find itself on the wrong side of a human rights violation. So right off the bat, we have that. The other issue, of course, is the temporary layoff. So she asked, can the temporary layoff be 13 weeks or can it be more? She said it's going to be 17 weeks. So let's actually correct that misconception. Again, this is something that I've been dealing with nonstop since the virus started. A temporary layoff, 13 weeks, 12 weeks, 50 weeks, doesn't matter. It's actually a termination on day one, not on week 13. It's on day one now. You can treat that as a termination right now and get your severance. So that's option that you have. Now, if you choose not to and wait, then a temporary layoff, if you choose to allow it to exist, can last for 13 weeks if your company does not continue your benefit coverage, and up to 35 weeks if the benefits are continued. But again, that only becomes relevant if you choose to allow it to exist in the first place. And many employees, as I said earlier, are choosing not to allow it to exist, not to accept it, because they can't afford to live off EI. They can't afford just, whether it's even $2,000 a month. A lot of employees say, I can't live off of that. I have a family, I have children, etc. I need my full income. So one way to get your full income right now is to get your full severance entitlements.
And plus, once the whole COVID-19 thing is done, I mean, you've accepted the layoff once, there's a good chance that they could do it again. They'd be justified in doing so, right?
And it gets worse. Exactly. You're right. If you accept the layoff now, you want to be the good team player, the good soldier, which I get, and actually I respect a lot, by the way. But if you do that, one of the things you're doing and risking is that by allowing the company to do that, down the road, even if it's not related to COVID-19, they now may have the right to do it again because you created that precedent. You allow it to happen the first time. So your employer may be able to say, yeah, you remember how 2 years ago when we had this COVID-19 thing, we laid you off temporarily? Now we're going to do it again. And at that point, you may not be able to do anything about it. So it's a very dangerous precedent to set. So you really have to think long and hard about whether you're going to allow the temporary layoff to exist or just pursue your termination entitlements.
There is another place for you to go. You want to ask questions, get some answers, terminationquestions.com. Again, terminationquestions.com. You can lay your questions in there, and either Lior or a member of his team get to answer them rather quickly. We'll get to one from Brandon. Lior. Brandon writes, I've been put on a temporary layoff due to COVID-19. Do I have to make a choice between asking for severance pay or applying for EI insurance benefits?
The answer is no. You do not have to make the choice in the sense that you can and you should do both. So you should, as soon as you're laid off temporarily, permanently, the first thing you do is you actually apply for EI. You should apply. You should get that application in. Right now, you can also apply for the, in fact, I would recommend doing that first, applying for the CERB benefit that the government just recently announced. So you can do that. But that does not stop you from pursuing your entitlements. Now, an adjustment may have to be done later, depending on when and how much severance you get. But no, it's not a choice. You apply for EI. You can still pursue your severance entitlements at the same time. Very good idea to do both. Why not get all the compensation that you're legally owed? Your family needs it. You need to support it. So you can do absolutely both, and you must do both.
Again, these questions from terminationquestions.com. Marshall's going to keep in lockstep with the conversation, the topic so far, and that is, can my employer refuse to work because they're afraid of contracting COVID-19 in the workplace?
So an employee does have the ability to refuse to work, but that refusal to work has to be reasonable. And here's what I mean. Okay. If you're working for a business that's deemed to be essential, if your employer allows you to practice proper physical and social distancing, if you're able to do that without undue risk, then your employer is allowed to expect you to be at work. I understand that you may have fears. I understand that you are very concerned about getting the virus or potentially giving the virus to someone else that may live with you, etc. But the way the law currently works is that if your employer can allow you to practice social distancing, if you're able to do that without more risk than is otherwise acceptable, you have to be at work. But that said, most employers now, my opinion, should certainly be understanding. So one of the things you want to be able to do is talk to your employer, explain the situation, offer to work from home, offer some ideas, maybe changing your hours where you can come in when there's less people at work. So there's things you can do to try to work with your employer, and an employer, I think, would be wise to work with you to find a solution. But beyond that, if your employer kind of can check all those boxes, you are expected to still be at work if that's what your employer wants you to be doing.
Quickly, got about a minute and a half before we wrap for today, pal. Sarah, last one says, my childhood school closed due to coronavirus. Can't find anybody to take care of them. Do I still have to go to work?
Yeah, you currently have the ability, and that's something that's specifically been implemented because of the virus. You have the ability to allow to stay at home, to work from home. Right. Your employer has to give you that time. You can even apply for benefits so you can get compensation. A lot of parents, a lot of individuals are in that situation. If that is your situation, you can stay home. Okay, Lior, last minute till we're done this week, pal. Final thoughts. John, I've been practicing law for many years. I've never seen quite this situation. I hope to never see it again if I practice another 50 years. But there's a lot of issues, a lot of employment issues that come up. If you have those questions, if you have those concerns, and I know so many do, reach out to me. There's no bad questions. If I've ever been here to help, now is the time that you should take advantage of that. Rights are not suspended. Employment laws are still here. They're there. They protect you. You need to know what they are. Start by making the phone call. This is an important time. Take advantage, and we'll be back here as time goes to update you on everything you need to know. You bet. 1-855-821-5900 is the phone number. Pocketemploymentlawyer.ca, and if you want to reach out, help@employmentlawyer.ca. Keep practicing that physical distance, that safe distance, until you're told otherwise. And we'll catch you next time right here, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.